Thanks everyone for coming to the very first session of the last day. It's always shows real dedication to get up and be here, and I really appreciate it. My name's Karen Sandler. I love my acronyms. This is not legal advice, and I am not your lawyer. I am the executive director of an organization called the Software Freedom Conservancy. Can you raise your hand if you've heard of Conservancy, if you know what it does? Okay, so that's almost everyone. Conservancy is a nonprofit home for about 40 free and open source software projects now, including many that you've heard of and use, like Git, Samba Wine, the list goes on. We also are the home of Outreachy, which is a diversity program for free and open source software, and the Linux kernel has been a participant in Outreachy with great success. We also are known for being the home of another project, which is called the GPL Compliance Project for Linux kernel developers. And we're also the home of the Debian Copyright Aggregation Project. I personally am in addition to being executive director of Conservancy, I'm also a lawyer, which when I speak, I kind of hide behind the podium in case anyone wants to throw any rotten fruit. But I'm only I only lawyer in the public good. So I'm pro bono counsel to the Free Software Foundation, GNOME, where I used to be executive director, and to questioncopyright.org, where I'm pro bono general counsel. I co-organize Outreachy, the internship program, and I'm also a cyborg. I have a heart condition where I literally have a big heart. My heart is 3 times as thick as a normal person's heart. It's called hypertrophic cardiomyopathy. And I have a pacemaker defibrillator, which I can't see the source code to. So I can't see the source code in my own body. And doing the research on medical devices and finding out how truly unsafe they are and what a scary situation it is for software, and comparing that to the merits in the long run of using free and open source software has made me a now lifelong advocate for free and open source software, and has made me really, really passionate about the public good side of free and open source software. These are mine and Conservancy's Twitter handles. So if you guys are looking at your devices or your computers, I know it's because you're totally tweeting about how awesome this talk is. So thank you guys. So I've been around in free software for a little while. I first came as a lawyer. It was before I even knew I had a heart condition and got interested in the societal aspects of free and open source software. I was a lawyer working in this space, and I come from actually a corporate securities law background. I was a lawyer actually in London doing cross-border transactions like stocks and bonds and things. And a corporate lawyer, it's actually a great place for an idealist to sit in a law firm is in securities law, because you're worried about making sure that companies are disclosing enough information for the public about what they're doing. And all of that was because I'm an extremely conflict-averse person. I really hate fighting. I don't even, even though I'm a lawyer, I even hate arguing with people. I would rather just have a nice little quiet conversation and move on. So when I first came to the free and open source software space, I was really tentative about some of the aggressive discussion around enforcement. I found that in some ways it was centered around really polarizing personalities, which kind of made me want to run away a little bit. And also, I thought for sure there were better ways of accomplishing this problem, like bringing enforcement actions which rely on ultimate potential legal actions and lawsuits seemed to me to be not necessarily the best way forward. And I was confident that in my participation, I would find these great, very friendly ways of getting companies into compliance, and perhaps no one had just tried a nice touch. But over the last decade, I guess, I've sort of learned a lot. I started out also being very license agnostic personally. Some of my clients were, when I was at SFLC, were X.org and plenty of permissively licensed projects, and I really bought into the different ideas of freedom, and I still think there's a lot of value in that, but I was very license agnostic. I thought it doesn't really matter so long as the code is out there. And as I've sort of seen how things progress, I've really started to understand how much copyleft is good for everyone in the long run. Seeing the accomplishments, for example, of the Linux kernel and how singular they are, and how the kinds of collaboration that are encouraged through copyleft has really impressed me. I know, did anybody here, was anybody here at LinuxCon Europe? So a few people. If you saw Martin Fink's keynote there, it was really amazing. And he was talking about the pendulum swinging back from permissive licensing to copyleft. And he talked about that for many reasons. Some of that was because with copyleft, you have this great neutral way for companies to participate with each other. All of these great member companies that are a part of the Linux Foundation come together around the copyleft licensing and the ways that we collaborate together to produce something extraordinary. But with permissively licensed projects, you have to create governance to overlay over it. You have to fabricate ways that companies are operating with each other, which often involve board seats that, where you have to tie donations to votes, and that connects to the ways that companies have control over the product. And seeing how developers have gotten frustrated with permissively licensed projects as they've been forked into proprietary products, and which sometimes wither and die, and developers not having access to their own code later. It's sort of, all of this has made me sort of get more understanding of how special copyleft is and how spectacularly it works. We at Conservancy, are in an interesting position because we have this compliance project for kernel developers, which means that individuals who hold copyright in the Linux kernel sign enforcement agreements with us to ask us to enforce their copyrights for them. A lot of our copyright holders are anonymous, and some of them fear that if they are known as being as prioritizing enforcement and wanting companies to comply, that they'll have a harder time getting a job. I think that that's starting to change, and more of our coalition is becoming public. But we've set up this coalition, and then also we've had some developers who just don't want to even think about this, and they simply have assigned their copyrights to us, even though, in fact, we weren't seeking copyright assignment necessarily. But now Conservancy is a copyright holder in Linux as well. And so when we go out and ask companies to comply, what's really interesting is that we get a lot of really passionate requests from developers, sort of like, sometimes developers will hand us the model numbers of products that they're so frustrated with their own company is out of compliance on, and will say, you didn't get it from me. I think that developers become so frustrated when their companies are out of compliance that they are particularly interested in us doing that. The other people who have given me passionate requests for enforcement are lawyers and heads of open source companies, because especially heads of open source, their departments rely on their companies being willing to invest in compliance. If their management doesn't see the value in compliance, the company simply won't invest the resources in actually causing this to happen. So while there's no consequences for not following the license, it means they have no business case to make. So if they have no one to point to and say, at the end of the day, if we don't comply, we could be at risk for a lawsuit, then nothing will happen. And so having this activity out there is really important in just being able to get the standard compliance. You can talk about compliance until you're blue in the face, but if someone, at the end of the day, sometime when companies are when companies are refusing to comply, if someone is not willing to ultimately file a lawsuit, then you may as well not start at the beginning. You can't even take the first step about education and compliance because no one will care. But we also get demonized for enforcement. So there's been a lot of really misunderstandings about what we do and how we do it. I've heard crazy things said about Conservancy and me and Bradley over the years about how unreasonable we are, about how aggressive we are. And part of that is that for the, some people call it the compliance industrial complex. So for the folks who have a business interest in around the industry of compliance, there are some scare tactics that if we look scarier, these companies will invest more in compliance, and it's a really tricky balance. But we've been really frustrated by the ways that we've been described as unreasonable when we have really focused on compliance above all else. We have focused on, today's violator is tomorrow's contributor, right? So anyone who's out of compliance today is going to be potentially a really important part of our community tomorrow. And approaching companies in that way is essential. And we have a whole host of ways that we have found over the years to talk to companies about their work and about their compliance to try to nudge them in the right direction, avoid lawsuits where we possibly can, and to get companies in compliance. And eventually, last year, we decided to publish these methods in a document called the Principles of GPL Enforcement, which we co-published with the FSF. And we basically codified this whole, compliance above all else, that we seek compliance from violating companies, not for profit, not monetization. And there are a number of different principles, which I won't get into now, but they're basically all ways that we commit to be doing our compliance in a very friendly way that is going to be good for business and good for adoption in the long run. And we ask for anyone who is enforcing in a community-driven capacity to do the same. There's some really interesting stuff. I could do a whole talk on that, which maybe if there's time, we can talk about it in the Q&A. But this talk is called Tales of Enforcement. And so you want to hear the juicy stories of what happens in companies when we talk to them. To get into the anecdotes, I would say that I should tell you about the overall process. Our compliance starts with an angry email, which we call the report. A lot of times when developers are reporting a violation, it's because they have tried to get the source code themselves. They have something specific they want to do with the code. Sometimes they're hobbyists, especially people who are trying to use a product and who want to make it better for themselves in some way. So we get, or sometimes it's people who are just, who notice that it's out of compliance and think that the software would be useful in the long run. And so they email us with an angry report, and then we, according to our principles, and just to be good actors in the community, we verify the facts, we check it all out, right? And then we try to find someone to talk to about it, which is not always easy. Companies who are active in the space, you come to a conference like this and you know who to contact. But for companies that are violating, who don't necessarily understand yet how to properly comply and interact with the community and the benefits that they're going to get from it, aren't present at these conferences, and so we wouldn't necessarily know who to talk to. And so we try again to find our contact. Then we ask for help in trying to find the right person. So sometimes we ask our friends at the Linux Foundation or other companies or other diplomats who have great connections with, in the field, to see if they maybe know someone if we don't. And eventually, if we can't find the right person, we'll just send a letter. And then after we've sent the letter, because we often won't get a response, we then try again to find someone to talk to. It's a hilarious holding pattern, and the act of enforcement is like one series of holding patterns that are incredibly frustrating. After you find the right person, we try to find the right person in engineering, or in management, but generally we will wind up face to face with a lawyer. Now, I don't have anything against lawyers. I play one on TV, so I'm kidding. But it's somewhat very frustrating in the course of this enforcement action that what happens is often companies bring in litigation counsel right away, and we sort of have to explain, that who we are and what we're doing. So the number of times that we have been accused of being a patent troll is really hilarious. And we're sort of like, no, take a deep breath. We're not threatening to sue you now. We hope that doesn't get to that. Let's talk about this. You're out of compliance. You're using free and open source software. Let's talk about it. How can we educate you? Let's find out, what you need to do. We really need to you really need technical people involved because they're going to understand this. And litigation counsel in particular is like a step removed from the company's business. And they effectively try to stonewall, which makes the situation a little bit more aggravating. But eventually, we wind up cutting through some of that because what I love is that is when we have these calls sometimes, they like try to lowball you out of the case, like out of any complaint that you have. So a litigation counsel might be, okay, can we just wrap this up? How about we pay you $10,000 today? And we're like, well, actually, we're not really, we're not interested in the money. We're interested in compliance. Like, you're getting this huge benefit from free and open source software. There's a really magical thing that happens with free and open source software, and you can become a part of this community. Your products will benefit, and society will benefit. I sometimes give my little medical devices spiel and talk about why it's so important. And so eventually we wind up cutting through that. And then what happens is we get a really, really awful source candidate. So we finally get them to understand that they need to provide source to us and along with their products. But they send us a terrible source candidate, which we then have to go and analyze to see how terrible it is, and then go back to them with a detailed complaint of what needs to happen to improve it. And we have a lot of back and forth on this, and they delay as much as possible because it's in their interest to sort of make this go away any way they can, and dragging their feet is often the way. My favorite quote from within the last 10 months is a violator who, when we told them about their violation, said, well, I'm going to have to talk to engineering. It's a lot of coordination for how about we have another call in a month to talk about timeline? It's like, what? That's a really long time. And I said, you have to appreciate from our perspective, it's very difficult. We're a nonprofit. We're very small. We only have 3 full-time employees. We're doing the best we can here. And what's tough is that we want to give you as much time as you need to come into compliance. We want you, like, if you're on the right track, we want to help you do this. We don't want to, but at the same time, if we don't light a fire under you, I don't know that you're ever going to do it. And this lawyer at this company said, you're screwed. And I said, what? And he said, you're screwed because you don't know whether I'm lying to delay you or not. And I'm not going to tell you whether I am or not. And I was like, okay, that is not very friendly. But it's sort of the problem with, it's sort of the problem with this work. We still have to keep a smile on, still have to sort of say, there's no reason to be hostile about it. We want you to participate. We want you to understand free and open source software, get the benefits. And at the end of the day, you don't have a right to distribute if you're out of compliance. I know it's the Terminator. It's a little dramatic, but you don't have the right unless you're unless it's restricted. You lose permissions under the license to distribute if you are if you're out of compliance. And so, ultimately, we have to sort of have those conversations where we're getting a little bit tough and saying, you still have products on the shelves. You still, you still have your relationship with your customers, but you have no rights now to be distributing that software. And we are not going into court right now asking for an injunction because we want to help you. And so eventually, that sort of gets through. It's very hard to convince companies that it's better not to distribute any code at all than to distribute bad source. And with such a diversely held piece of software or project like Linux, there are so many copyright holders that even if we restore rights or we allow a company to distribute a product that's in violation, there are other copyright holders that might have a different opinion. The only way to be sure that you're going to have your permissions to distribute the software is if you're in compliance. And getting to the end of the process and having a really compliant really compliant product is the only way that you're going to insulate yourself from liability going forward. So we usually have a bit of a standoff. And what happens is that at the end of the day, often it comes down to that company's vendors. So often that company has has a vendor that's supplied them with software and haven't provided a source or offer for source for them. But the software is so integrally built into their product that they're not willing to sort of go back to their suppliers and say, hey, actually, you guys didn't give us the source code for what you've supplied to us. And so it's quite difficult because we know then ultimately that sometimes we're dealing with someone who's actually a victim of a violation themselves, but they're not willing to necessarily turn around and say that that's the case because it's so expensive for them to find a new supplier, which is extremely, extremely frustrating. Like, so frustrating. And for a long time, we have tried to get companies to sort of join us and turn around and do enforcement with their, for their suppliers, but it's been a real uphill battle. But this GPL compliance work, enforcement work, is very, very colorful. When the lawsuits were filed in the Best Buy litigation, all those years ago, we got to see some of this stuff shake out in court a little bit. And what's funny is the way that companies do all of these like corporate machinations in order to reduce their perceived liability before the court or in general. One company wound up declaring bankruptcy in the course of the proceedings. And they petitioned the court so the lawyers petitioned the court to be removed from the case because they weren't getting paid because the company had declared bankruptcy. And then they formed a new company with some of the assets. And during the court discussion, there was the old lawyer was sitting in the audience in the court making hand gestures to the new lawyers, basically and then eventually shouting out what they were supposed to do. It was that flimsy of a corporate shield. And another funny corporate situation was that there was one company that said that they had been losing money on their products all along because they had a terrible relationship with their vendor, which was a Taiwanese company. And when we dug into it a little bit more, it turned out that what the company, the company was named Fu, and the supplier was Fu Taiwan. So it was like a whole entity that had the same name, but was a Taiwanese company that gave them bad deals every year on their software. So we really have seen a lot of nightmare scenarios, and a lot of companies that, until they really understand the benefits of free and open source software, really try to waste their time, because eventually, if they can get to their product's end of lifing while we're discussing, we're really interested in compliance for ongoing products. So there's a real incentive for companies to sort of drag their feet as much as possible and to waste their time. We have, typically for companies that are out of compliance that we're talking to, we'll do like 20 turnarounds, and each time we have to analyze their source candidate every time. And we've had many more than 20 as well, and it just takes a really long time. And we're only 3 full-time people, and we've got a lot of other important things to do. We have 40 free software projects that need our help. We have to run outreachy and run all sorts of other important stuff. But it's worth the effort. And the exciting thing is that there really is hope. There's been a lot of progress, and there are some good stories to tell too. So, for example, there's the speediest compliance. There was one company that had no source or offer for source with their products, but within a day and a half, they came into compliance. And without being asked for it, because I actually wasn't involved in this matter, but without even being asked for it, they wrote a check to cover the time spent working on it, even though they weren't even asked for it. So normally, when we do compliance, we ask for our expenses to be reimbursed, and we keep track of our hours and things like that, to make sure that, to be very clear that we're not asking for like a for-profit settlement amount. Sometimes companies choose to give us a donation along with it because they're happy that it's been resolved and they find religion. But then there's also examples of excellent compliance, and it's so frustrating because sometimes companies come into compliance, but we offer confidentiality to companies that we talk to because we understand that if they wind up publicly talking about the fact that they're out of compliance, then some other copyright holders in Linux could come and they could be liable for the infringement. And so we're very happy to help and keep things confidential so long as they come into compliance. It's a good way of engaging companies and making sure that they understand that we're not trying to get them in any way. And so it's been frustrating for us because sometimes when things go well, we can't talk about it. We don't have the, we can't make a press release. We can't do anything. Nobody knows about it. We know that the world is a better place because there's a better GPL compliance, but we don't have the ability to tout it. So recently we published, last year we published a guide with the Free Software Foundation on copyleft.org, which is itself copylefted. So if you're interested in this stuff, you can go on copyleft.org and read the guide. And if you have patches, are very welcome. This stuff can always be improved, and we need assistance from lawyers and non-lawyers alike. Even just readability. If you read something and it makes no sense, just asking the question for clarification, it's super helpful. But one of the things that we did last year was we published an analysis of source code to show companies what it is we're looking for when we ask for compliance. And in order to do that, we needed to show an excellent example. So a company that was really doing the right thing, because we can't show an example for any company that's not fully in compliance. And so Think Penguin had this wireless router that was really excellent, and you can read the full analysis of why it's excellent and how it worked out. And in the vein of happy and good stories about compliance, Think Penguin has a copy of our analysis framed on the wall at their company. Also in happy news, there is movement regarding vendors. We're now in negotiations with a company where it looks like they're going to provide an affidavit where they're going to basically go on the record that they got code that wasn't GPL compliant. And I think that it's been difficult to convince companies that this is the right thing to do because we don't want to go after a company that themselves is a victim of a GPL violation. It doesn't really make any sense. We want to be in the position where we're assisting these companies in turning around and asking their vendors for the complete and corresponding source code. And so now we're in a situation where it looks like companies are starting to contemplate this. And if in aggregate companies started to ask tough questions from their suppliers, and there are lots of reasons to do this. And when I give continuing legal education classes with lawyers who are interested in free and open source software, I tell them about this and I say, you need to really talk to management and talk to developers when they are evaluating which pieces of technology to use in your products, that you make sure you have the corresponding source code for everything that you possibly can. And if you're if you're purchasing software that has GPL components, you should get complete and corresponding source code and the scripts to the scripts for installation, because if you have a security vulnerability down the road, you have a great relationship with your vendor now, but you might not later. So there are all kinds of great security and other reasons why you want to have really good copyleft and really good GPL compliance that are not managing this risk. But managing risk is certainly another reason. It's a good way to motivate in-house counsel to think about this. And so as companies sort of start to understand this, they're more willing to turn around and put pressure on their vendors. And that's been a big problem we've had in this space. I see some people are nodding here because they've experienced this themselves. At the end of the day, all of the stories I have are sadly hilarious conversations with in-house counsel. There was one call that we did a couple of months ago where the lawyers consistently made us wait. Every time we'd scheduled a phone call, we would wait for 15 minutes before they would even join the call. And one time they made the mistake of inviting engineering to participate in the call, but hadn't clued them in on this strategy. So engineering dialed in when we did on time. And so we started chatting, and I sort of said, I'm a lawyer and your legal counsel isn't here, so we can chat about stuff, but don't talk about anything that is related to the legal issue. There are legal ethics. Like, as a lawyer, I can't. Often I'm behaving in a non-legal role, but since I'm a lawyer, I'm still really nervous about this stuff. I don't want to get caught out, on the wrong side of any legal ethics issues. And so, and they said, oh, no problem. We're just going to look at this matter right now, and we'll get up to speed while we wait. And we're like, okay. And as we're waiting 5 minutes in, while the legal counsel was making us wait, they said, oh, this stuff is totally GPL'd. And I said, your legal counsel isn't here, you should wait. And they're like, what are you guys again? What is Conservancy? And they're like, that's so cool. And they started sort of talking about it, and I sort of said, your legal counsel, and then when their legal counsel came on, they took over the call, and it was a really funny experience. But it's one of those things where I think companies put up these legal walls, and they're worried about it. But if they understand that it's a process and that they can work with engineering early, then they'll be so much better off. And we, as the Conservancy, and I can speak for Conservancy, and I know the FSF feels the same way, we have no interest in litigating. We don't want to bring lawsuits. As you may have noticed, there have been very few lawsuits in all the time that these products have been available. And since the GPL compliance project for kernel developers has been launched many years ago, we've only had one lawsuit, which is the lawsuit that Conservancy funded that Christoph Hellwig brought against VMware. So we do everything we can to prevent lawsuits and everything we can do to help companies comply, because community-driven enforcement is good for everyone. It's good for the community. If companies don't take their compliance seriously, we don't have the benefits of copyleft. We only have those benefits when companies are playing together on a neutral playing field, when they really are working together as an industry. And you can help. As developers, the best thing you can do is to think about the business issues involved in choosing the software that you recommend. And if GPL code is the right code to include, having a meeting where you think about the business implications of doing so and making the case for how compliance will help your company is going to be huge and having that conversation early will make them ready to do the right thing. Making sure you've got good procedures, because as we all know, there's so much turnover at companies, and a lot of times when we engage in enforcement actions, the main developers on the product are long gone, and nobody knows exactly what they did, and there's not really great documentation. So building processes and documentation internally really helps too. The lawyers that I know who are really, really awesome in free and open source software are lawyers who either have a very strong technical background, like I was a programmer before I went to law school, or are lawyers who partnered up with an engineer, with a developer, and I work closely with Bradley Kuhn, and it's been really helpful to me. And seeing the lawyers that have both of these, that do both of these things and really understand the technology and work with a developer are leagues ahead of the lawyers that are trying to understand it. And when lawyers are put on the spot and they don't fully understand the issues and they haven't had time to think about it and they don't have someone who they trust, they're going to say no. They're going to default to saying, well, let's use as little GPL code as possible, only permissive licensing, and they'll lose the benefits of copyleft over time. But if you are proactive about it and you build relationships with legal when there isn't a problem, it makes a massive difference. And as people are more educated, and if they feel safe that they know someone who is on their side, who's in their company, who will work with them, it's a completely different thing. And of course, the last way that you can help is that we always welcome people to sign up for our coalition of kernel developers. I have some agreements here. So if anyone is interested in signing up, just approach me afterwards. The OpenWRT project is a really good example of a project that would never it actually would never have been started, as I understand it, if it hadn't been for an enforcement action that had been taken. Having companies release the source code for their products is good for everyone. In the long run, a lot of these routers have a whole other life because of the software is available for modification and for people to work on. So hopefully we'll live in a world where we have more source code and more ability to modify our own products. Conservancy is a charity, so we rely totally on donations, and we recently switched to a supporter model. We found that bringing a lawsuit at all, even one where we had talked to the company for 4 years before we brought the lawsuit, even though we had tried to work with our allies, and even though we've done everything transparently, has made companies shyer about funding us, which actually makes a lot of sense, but we've had companies that have tried to exert their position as a donor to get us to do certain activities. And we're a charity, and we operate in the public interest, and we are here to support the GPL and kernel developers. And so we've pivoted our business model. We still are very appreciative of our corporate donors, and companies gain a lot from our work. Companies will benefit in the medium to long term, definitely from having enforcement happen. But in the short term, putting so much of our funding in the hands of companies means that we are subject to pressures about how, what cases we'll take and what we won't take, and it's simply not the right result. More importantly, it's not enough if Bradley and I think that compliance is important, and a handful of developers. That's not enough. We need to know that the public cares about it, and so we've had 1,000 people have signed up since we've started promoting it in November, and so becoming a donor helps us financially and gives us the right incentives that align with the public, but also it shows the public that people care about GPL compliance and they care about the GPL. So thank you very much. And I think we have time for questions. Yeah, go ahead. Do you want to come up and use the microphone, or is that too formal? Because then you just have to turn it on. Then I don't have to repeat the question. Oh, he's right there to.
I need new glasses, obviously. Okay, so firstly, thank you for the work that you're doing. There's a lot of work that's required to swing the pendulum back towards copyleft, right? There's a lot of marketing and evangelism. How do you balance that with enforcement? Enforcement has to happen, but then it's scaring off corporations from GPL and LGPL submissions.
That's a great question, and that's one of the main reasons why we published the principles. We found that because when we approached companies for enforcement, we were sometimes interpreted as trolls or as hostile, and companies didn't necessarily believe that we really wanted to assist them with their compliance. So putting these in writing actually curtails what we even can do now as enforcers. We are now bound to the principles that we've published, and that is it's an advantage to the companies that we approach for compliance. And being able to point them to this document and say, you're out of compliance. We want you to come into compliance, and to show you that we have good faith in this process. You could read our principles, and if we don't follow them, you should call us on them, because we mean to. And companies have also found that to be helpful, if other people approach them about their compliance, they can point to the principles and say, community-oriented folks like Conservancy and the Free Software Foundation, do this in a principled way. Are you principled? So codifying our principles is a main way about this. And another way is to sort of really try to find contacts within companies that are violating, rather than just sending nasty grams to legal. It gets very frustrating. I really understand why people who have done enforcement for a long time become so aggressive and abrasive about it and get really cranky about it, because it really beats you down, like over and over, having the same conversations and having to explain the value and having having people in-house at companies trying to game the system as much as possible. But I'm really encouraged by the successes that we've had. And I really think that the tide has been turning a bit back towards copyleft. Young people are very excited about copyleft again in a way that they weren't before. And I think we're starting to see the negative parts of the permissive world that we've created. I think, seeing these fragmentation that happens and as I said, the forks that wither and die, it means that developers are sort of, realize that they really gave up quite a lot when they allowed companies to convince them that lax permissive licensing was better. And they've traded short-term adoption for a long-term healthy ecosystem. So I'm actually quite hopeful, and I'm thinking that I think things are changing quite a bit. And as we have more success stories, I think that will help change the tide as well. That's another question.
So I'm not a lawyer. A lot of my friends aren't lawyers, and yet somehow it seems like we always end up arguing like lawyers. And one of the things that seems to come up when we just talk about GPL compliance is the idea is that there needs to be sort of a canonical test case or sort of a test case lawsuit to actually say this is how it's supposed to go. And especially as I think the direction things are going in terms of expanding things about can the GPL be used with this, and especially talking about combining licenses. So is it actually true that there will eventually need to be some sort of like test legal law case for it to be true, or do you think that ultimately we can get an answer about can the GPL be used with this without actually having to go to litigation?
Great question. We used to think that we didn't want litigation. We used to think that if we brought lawsuits that we might get an answer we wouldn't want. And so it was better to not bring the case at all because the risk of a bad decision was too high. But as a result, companies have behaved as if the GPL were not as strong as I believe as a lawyer it truly is. Lawyers will give you very different answers when they're speaking in their personal capacity and when they're speaking on behalf of the companies they represent. And as a lawyer who's never, who hasn't been on the company side of it, it's very hard for me to sort of see the arguments for weakening the GPL. But nonetheless, there's ambiguity. We don't know what the answers are until the lawsuits are brought. We still don't want there to be lawsuits. We just want there to be compliance. But where we have violations where that's the case, so VMware is a good example of that. When Conservancy started its compliance action against VMware, it was a no source or offer situation. And we actually made progress with VMware where they wound up doing a lot more and coming into compliance a lot more. But then we hit the point where they said, we believe we have done, we believe that's all we're going to do. And so we had to bring the lawsuit. I believe that bringing this lawsuit that Christoph has brought is really important because I think at some point we need to know. It's been very expensive. Lawyers in-house have been making these decisions over and over again. They each do their own analysis. They come to their own risk analysis of what they think it's an appropriate position to take and what the impact will be if it goes south. And they've made a decision, and it's expensive. Every company is doing this individually, and they come to their own conclusion. And there's a lot of uncertainty, and there's risk to everyone. So having this done in a way where the issues are laid out in a very fundamental way is I think going to be beneficial. And while I will be disappointed if it turns out the GPL is weaker than I think it is, and doesn't do as much for copyleft as I thought it did, I'll be happy to know, and we can just move on. And so even talking about lawsuits and getting that adversarial makes me really jittery. But so I don't want to do that. But I think that since there are so many companies that are willfully out of compliance on it, over time we may have to bring those lawsuits. And then we'll know what the answer is, and we'll be better off. There'll be much more safety and structure to the community as a whole. And so I think that's the case. Does anybody else have any questions? Mm-hmm.
Speaking of VMware and Hewick's lawsuit in Germany, that was, I guess, last March that it was filed, and I really haven't heard anything about that case since then. Of course, As I know, and as we know, but maybe the audience doesn't know, in Germany, the court's records are not public, whereas in the United States, I can tell you pretty much on a day-to-day basis. So I guess my question is, as someone who served as an insider, can you tell me what the status of that case is today?
Yeah, as a U.S. lawyer, it really stunned me, and I didn't realize how U.S.-centric I was until I found out that the court documents would not be public in Germany when we did that. So it was a real surprise to me. There are a lot of good reasons for having that system be the case. People bring frivolous lawsuits, and there's a negative impact on the defendant of a lawsuit if the lawsuit has no merit. So there are good reasons. I understand why the German system is like that. But for the VMware case, Conservancy is not a party to that lawsuit. So we're not really, we're only quasi an insider. We're funding the lawsuit, but we're not a party and we're not engaged. But there was a hearing last month where the judges, the public could come in, and some kernel developers were there. Harold Welty published a blog post about it, and we published a little statement as well, talking about what the judges asked for. They sounded way more clueful than I would expect any judge to be, and they asked really interesting, on-point questions. And so it'll be interesting to see what happens. I've been burned in the past by trying to read too much into oral arguments during this, I think it was the Supreme Court Bilski case. I got super excited because the questions that the judges were asking really seemed like so dead on, and I thought they were going to issue a much more sweeping opinion than they did. And your heart can be broken only so many times. So we'll see what happens. But at least I'm encouraged that the judges seem to understand some of the technical questions in a way that I wouldn't certainly expect a U.S. judge to know. So we'll see. I think from what I understand of the way German proceedings work, I think the earliest we'll hear about the case is next month. But I also understand that there have been a lot of extensions filed by parties, and so the case continues. Anybody else? I think we're just about, we could maybe do one more if anyone has, or. Great, well, thank you so much.